Oh, yes, sir. Your Honor, this is Ryan Peterson before the court on 25 CF 1926, 25 CF 2240. I did speak with some people outside of court that I anticipate will be witnesses on his behalf, so I need to get more information so I can list them in discovery, in our reciprocal discovery. These cases are relatively new, so I haven't even shown him or had the opportunity to show him the videos yet. So request a continuance to 4/29.
Without objection.
4/29 at 9
I
o'clock.
can put him for one. Your Honor, this is Timothy Thacker before the court on 25 CF 2263, 25 CF 2444, 25 CF 2279, 25 CF 2338. We have now gotten the discovery in the cases. I'm going to need to show him videos and all the cases, and based on my discussions with him, we'll need to set depositions. But we're not there yet because I haven't even shown him all the videos.
There's 4 cases, but they're all new.
Yes, sir.
All right. April 29th, 9 o'clock.
Thank you, Your Honor.
I'm aware of Shanklin and Pernell Thomas, but I don't have them right here yet, so.
Fields?
Yes, Your Honor. Deshaun Fields, 25 CF 1946. Hey, Mr. Fields. Your Honor, I am asking for a continuance in this case. I'd like to continue investigating it. It's only its second time up.
April 29th, 9 o'clock. But next time I expect to hear about progress.
Yes, Your Honor.
Brown.
Your Honor, this is Mr. Brown before the court in 25 CF 1828. Your Honor, I am asking for a continuance in this case. It is only the second time up. I would like to continue investigating this case as well. I do need some additional body camera in this case, Your Honor. I'll get with the state on making sure I get that. May need to take depositions in this case. We'll see, Your Honor.
April 29th, 9 o'clock.
Thank you.
May I, Your Honor, just 1 second. Mr. Maddox, can you indicate if you're missing all the body cameras?
No, not all of it, just a couple. I'll get with you on the particulars.
Okay.
It's the part where they're speaking to Mr. Brown, and then there's also some statements indicated where they're speaking to Kylie. I think that might be on body camera, but we'll need to check on that.
Just let me know and
I
I
will.
will address it.
Thank you.
And then back to Mr. Williams with Brandon Dykes.
Judge, this is Brandon Dykes. Case number, I don't have it on me.
Trying to find it. We're hopping all over the place right now.
Yes, sir. Oh. Okay. Is this
Oh, no, I was just
some more
giving
for me
the
to look
case
at?
number.
Oh, no, all right. No, it's actually, I can find it on here. It's gonna be 21 CF 1909.
All right. What are we doing with Mr. Dykes?
All right, Judge, so Mr. Dykes and I've been meeting. He had a motion to suppress that he wanted me to file. I've been working on that, drafted up draft motions for both cases on that. He's looked them over. He had some changes he wanted made. We've gone back and forth on that. I think we've spent probably 4 out of the last 6 or so days, sometimes meeting for a little bit longer period of time, sometimes meeting briefly just to exchange drafts. Also have provided him with his discovery depots. He's indicated notes on those and returned them back to me. And then I'm copying and giving him back a copy with his notes on it for his use. So we're moving forward on it, Judge.
Okay.
He indicated he'd rather spend his time on that than looking at videos at this point.
Your Honor, I'm trying to, I would like to inquire into whether the motion to suppress applies to both cases. Is it the same motion to suppress?
I'm going to file the same one in both cases.
Okay. Because I was going to suggest that if one case doesn't have a motion to suppress, we're ready.
No, I'm going to file it in both cases.
All right. Those are going to be heard before April 29th.
Yes, sir.
Okay, thank you, Your Honor.
Because unless you're telling me there's anything else that needs to be done, they'll be set for trial at that point if they're not resolved. Cases are from 2021.
Yes, Your Honor.
I know there've been issues, but cases need to be resolved.
Yes, sir.
All right.
Thank you, Your Honor.
So
Thank
make
you,
sure you
Judge.
get those filed, get them set for a hearing. Don't wait till the last possible hearing day. I'm not saying you would do that, Mr. Williams, but I just feel it's necessary to put on the record.
Yes, sir, I
That
understand.
needs to be done, and these cases, if not otherwise resolved, will be set for trial next cycle.
Thank you. All right, Mr. Dykes.
Continuance.
Don't know for sure it'll be today because I got a bunch of other folks to see, but it'll be soon. I'll be out again on Sunday.
Mr. Harrison, thank you.
Okay. Judge, this is Willie Holston.
Harrison.
Harrelson, I'm sorry. I skipped ahead of you. Judge, Mr. Harrelson's going to be a plea. I flipped 2 pages instead of 1.
As far as the misdemeanors, is that just going to be time served now?
Yes, sir.
All right, Mr. Harrison, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Robert Harrison, 1961,
The date?
7261.
Part of that is to make sure that you're the right person because,
Yes, sir.
you know, we don't want to have the wrong person up here. All right, Mr. Harrison, you're here in 24 CF 2402, charged with aggravated battery with great bodily harm and a weapon. That's a first-degree felony, punishable up to 30 years in state prison. And 24 CF 2838, felony petty theft, third-degree felony, 5 years max. And then 2 misdemeanors, possession of paraphernalia and resisting without violence, which are 1-year county jail max each. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would call for you to plead nolo contendere or no contest as charged. In the 2402 case, that will be 70 months DOC, 967 costs to judgment. 242838 would be an adjudication of guilt on the felony. It would be 60 months DOC concurrent, 515 in court costs, judgment. and a $150 PD fee. On the misdemeanors, it'll just be time served.
Sir.
Is that what you want to do here today?
Yes, sir.
Is that the state's agreement?
It is, Judge, and this is in accordance with Marcy's law.
Okay. All right, Mr. Harrison, did you have enough time to go over this plea agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Getting louder.
Sounds like it's coming from that way. Oh, okay. It was just dog whistle. Only I can hear it. All right, so, Mr. Harrison, are you satisfied with your attorney's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I've read to you?
No, sir.
And do you understand that by entering these pleas, there won't be a trial of any kind?
Yes, sir.
Do you understand that you're giving up your trial rights, which start at the very bottom of page 1 and go on to page 2 of that agreement that you've signed?
Yes, sir.
And do you understand you're waiving all potential defenses that you may have?
Yes, sir.
You also understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country.
Yes, sir.
All right, based on those things, what is your plea as to the aggravated battery, felony petty theft, possession of paraphernalia, and resisting without violence?
Contest.
I'll accept your no contest plea as freely, voluntarily, and knowingly given. In 24 CF 2402, it's going to be adjudication of guilt, 70 months DOC, 967 court cost of judgment. 24 2838, it's going to be adjudication of guilt, 60 months, Department of Corrections concurrent, that's on count 1. The misdemeanors will be just time served. 515 cost of judgment. Shouldn't there be 2 PD fees? Should be 100, 150.
Yes, sir, I guess so.
Okay, I gotta do it the right way. That's a total of 200, that's $100 on the first case, 150 on the second case for PD fees, also go to judgment. This is a guideline sentence. Guideline is 60.075 months. So, Mr. Harrison, I will need your fingerprints before you leave, and then you have 30 days to appeal the judgment and sentence of the court.
Yes,
Good luck
sir.
to you, sir.
Thank you.
Good luck to you, sir.
Thank you.
Mr. Holston.
Come over here, Mr. Holston. Judge, we took deposition in this case. It did change things substantially. The state's working on a new offer. If we can put it on for 3-2, we're anticipating it'll be ready by then.
Okay.
Without objection, Judge.
All right, so Mr. Holston, we'll see you back on Monday, that's March 2nd, at 9 o'clock. I'm going to mark it as plea, or you want it plea continue?
Yes, sir.
All right, we'll see you on Monday, Mr. Holston.
All right, sir.
Mr. Horn.
Judge, we got the, this is
Joseph Horn, 24 CF 811.
Yes, sir. We got the evaluations back yesterday. I went out and went over it with Mr. Horn, gave him a copy. My understanding is the court's received a copy
I
as
did,
well.
reviewed it.
I don't know if at this point we need to set him for a competency hearing.
Is there a second one?
No, there has not been. I have inquired of Mr. Horn whether or not he wants me to seek one. I've not had a chance to talk with the state about whether or not they want one. I would be surprised if they did.
The state, forgive me, the state would stipulate to Your Honor's use of the report for competency evaluation. We won't be seeking another.
The state's not seeking one, okay.
Up to you.
All right, Judge. Let's leave, I'm not going to seek for another evaluation.
What do we want to do with the case? Do we want to set up for trial again? Because
Judge,
just for the record, the competency issue came up, was it at jury selection?
Yes, sir.
The
Or
day
even
of
at the-
jury selection.
Say
Yes,
again?
The day of jury selection, right
Okay.
before.
I thought so. I just didn't want to confuse if it was the first day of trial or was it jury selection.
No, yeah.
But it came up, there was some confusion. Mr. Horn had indicated he didn't seem to know what was going on there, and at that point, I think I had said I'm going to have him evaluated. We have an evaluation back. It says that he's competent. Are you willing to stipulate to that one report, Mr. Williams?
Judge, I still have concerns, but I don't know that I want to push things off any longer. Will the court give me until 3/2 to make a determination on that?
I just want to know if we're potentially setting it for trial.
Yes, sir, I understand that.
I don't want to be in a situation where I can't, if we're not going to have the competency hearing right away, then it'll end up getting continued, and we're not going to potentially go to trial until May.
Yes, sir.
Is that what your client wants?
Judge, I talked to my client yesterday after we got the evaluation back. I've talked to him just a few moments ago. I asked him what he wanted to do, and he says that it's up to me.
Well, it's not.
Yes, sir.
And I think you know that, Mr. Williams, and I know you're trying to be a good lawyer and have a good client relationship, but at some point, these cases need to be resolved.
Yes, sir.
So we're either going to have a competency hearing, or you're going to ask for another one before we do that. But it sounds like if there's no issue with getting a second competency review, if you're not stipulating for it, then we're going to set it for a hearing on that. I'm not going to play these kind of games about continuing cases. I'm not saying you're doing it, Mr. Williams, but if there's nothing else to be done before we have a hearing, let's either have the hearing now or set it for another date for a hearing.
Judge, we can go ahead and do the hearing now, I guess.
Are you willing to stipulate?
I'm willing to stipulate. Largely agree with Dr. McDonald's determinations.
All right. Let's do this, Mr. Horn. Can you raise your right hand to be sworn? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
All right. Mr. Horn, there seems to be some question as to, should we have a competency hearing today? Have you had a chance to review the report?
I read it, and what I read, I can't remember a thing I read. Really, I mean, I can't. It's not.
You know, if I can interject based on that, let's just go ahead and get it on.
All right, we'll get you another evaluation then.
All right, Judge.
You can send me an order, Mr. Williams. It's going to be April 29th at 9 o'clock for your next pretrial conference. So another doctor is going to come out and meet with you, Mr. Horn.
Yes, sir. If we do it internally, I'll let the court know that's what we're doing.
Well, I mean,
It's easier
on-
for me to do it that way.
based on what just happened, I mean, we're either going to have a hearing or not. And we're not going to decide, oh, we might do one and not disclose it. 'Cause
I see what you're saying. All right, I'll send you an order, Judge.
I'm not trying to be difficult to you, Mr. Williams, but it feels like all of a sudden this is a situation that seems to be some sort of stalling tactic, and I'm not going for it.
Oh, what?
He is concerned that we're stalling the case. No, Judge, it's purely based on him saying that he can't remember what he read.
Well, I understand that. I understand that's what he's claiming.
I'll do up an order, Judge.
All right, thank you. All right, we'll see you back on April 29th, Mr. Horn. Have a great day.
And we're on 429, is that correct?
Yeah, it's 4:29, 9 o'clock.
All right, Mr. Herpes. And I'm probably mispronouncing that, sir. I apologize. This is another one. I did a counteroffer on it. We're waiting on a response. We can send him 3-2. Hopefully, we'll be able to move forward on that day.
State has a response.
Oh,
right now,
okay.
Forgive me. It would be an adjudication of guilt, 2 years probation, substance abuse evaluation, recommended treatment, 615 court call.
You want to write that up and bring it back later, or do you want to have a chance to discuss that and bring it back Monday?
Let me discuss it with him, bring him back Monday. There had previously been a probation offer in the case, I'll discuss it with him Monday. I don't want to go into our discussions.
Okay, and if it's not accepted, what do you want to do on Monday?
Judge, I don't think we're going to be ready for trial if it's not accepted.
Okay, March 2nd, plea or continue?
On all of these where we are waiting for an offer or changed offer, it's plea or continuance. I'm not.
I understand. I don't want to say plea or continue, and then we show up on Monday and one of your clients, and certainly not Mr. Huertas, I'm not saying anything, but anyone in particular says, well, I'm not taking it, so now I want my trial this week.
I understand, Judge.
So I'm just kind of putting all that stuff on the record as we go through them.
Yes, sir.
All right, go ahead. March 2nd, 9 o'clock, plea or continue.
Judge, this is another one. We have a counteroffer, and let's set him for the 2nd for plea or continuance as well. Maybe we can get it resolved, get the case behind him.
Without objection.
I mean, was this a counteroffer made today?
It would have been last night, maybe.
All right, we'll see you back. Plea or continuance, we'll see you on Monday.
Sir.
Mr. Henry Jackson.
Judge, this is Henry Jackson. Mr. Jackson's charged in 2025 CF 1754. This is another one. We took depositions in it. The depositions went fairly well, and we're awaiting the revised offer.
That's correct. If we could put it on 3-2, I'll have my decision by that time.
All right,
And that'd be plea or continuance, Judge.
March 2nd, plea or continuance, it's 9 o'clock. And then, Mr. Sprouse, if you can make sure to give that decision hopefully before the weekend. I know Mr. Williams typically goes on Sundays to the jail to meet with his client, so that way on Monday, it's not a whole new discussion, so they have a chance to talk about it in advance.
It might be a filing that's done.
Okay,
Won't object to that.
gotcha.
All right, sir. Judge, this is Michael Jackson. He's got 2 cases. One is with us today. We're waiting a ruling from the court on the motion to suppress.
And I think I brought this up during I finished 3 suppression orders last night at about 11 o'clock. Was when I sent them to my assistant so they could be ready to be filed. On Mr. Jackson, I am denying the motion. I think I talked about the whole bicycle covering the license plate part.
You did.
While we were here, so it's really just about the marijuana part. And I've explained this all in the order, I just haven't had a chance to sign it because I've been sitting here all day. But the issue basically is, and I just had the same issue come up when I was in Escambia County covering the other day. It's the case law, it's called Baxter, and then the Williams case that you brought up, Mr. Williams. They both talk about what the case law was at the time. Just as a reminder, in Mr. Jackson's case, it's an arrest from January 2nd of 2024. At that time, based on the Baxter case that came out about 8 months later, that where as long as officers are complying with what the then prevailing or precedential case law, then it's a good search. I know the law has changed since. If this exact case came to me today on a search that happened this week, then the decision would probably be different, but that's not what we're dealing with. So, but I'll have the written order, again, it's done, I just have to have it in the system so I can sign it. And frankly, usually when I do that, I kind of read through it one more time just to make sure. But that's it. It's the Baxter case and it's the Williams case that you brought up.
The one where Judge Bilbrey did the,
I don't remember which one he did that on. I know we talked about that when we were here last, but I've had 3 cases that involve this issue that I've been dealing with. But and it's the timing of it. Again, I think it would have been, I could say it would be different today if it happened today, but the officers might have done things differently had it happened today as opposed to 2 years ago before that Baxter case came out. So,
given the court's ruling, I'm going to need to have a conversation with him about what his options are. I assume everybody would agree that the motion was dispositive.
Yes.
So I'll talk with him
if
about
the state's
that.
willing to agree to that, that's fine.
When does the court, now he's got the second case scheduled for arraignment tomorrow. Currently, his bond's been revoked on this case. Does the,
Showing on tomorrow.
oh, it's 26229. I say, no, I'm wrong. It's not tomorrow, it's 3/5.
Okay.
It's 3/5.
And what's he charged with on that one?
Trafficking in that.
It is trafficking as well? Okay. All right, so what would you like to do today?
Judge, I'd like to go over his options and have him have a chance to think about it. Just in short, it's going to be either a plea and reserve the right, or go ahead and go to trial on it. And since he's going to be having that other case pending anyway, I would rather not have to rush through this between now and Monday. But if the court wants us to do it that way, I'll of course do it.
I'm not going to require that to happen, but also this is a case that, as I just mentioned, is now over 2 years old.
Yes, sir.
And frankly, if it wasn't for the new case, I would probably say we'll see you on Monday and it's going to be plea or trial.
Yes, sir.
But again, I think we just had this hearing a couple of weeks ago, but I'd like to get these decisions to you sooner. As you know, I've been here
I understand.
or covering in other counties.
Yes, sir.
Pretty much nonstop over the past 2 weeks. So I'll put it on 4/29 if that's what you're asking for.
That's fine, Judge.
But let's see if y'all can somewhat fast-track discovery in the new case to see if there's anything y'all want to pursue in that.
Yes, sir.
So that way he can make a decision on kind of those global issues as opposed to just individually. But 4/29 at 9 o'clock. And I would guess, again, you'll have that written order depending on how long it takes us to finish this up. But
I understand, Judge.
in fact, I think they're all in my queue now, but again, I'd like to make sure because I don't want to end up signing the wrong version of it or something if I don't. So.
Mr. Jackson, in the interest of time, I may mail you that order and then come out and talk with you if you've had a chance to review it, okay?
I need to speak to you as soon as possible. So
Yeah.
that'd be great. All right, thank you.
All right.
Thank you, Honor.
Well, you'll be seeing me tomorrow. Or not tomorrow, 3/5. Judge, this is Victoria Keebler. I'm going to move to continue. Case number is 25 CF 2085.
All right, Ms. Keebler, your continuance motion is granted 4/29 at 9 o'clock.
Thank you, sir. Okay. Okay. Judge, on Mr. Lee's case, we're again awaiting a revised offer after depots.
Oh, okay. I thought this was,
He's got,
you got an internal report back already, right? Or I have that wrong.
I think you've got that. I think you might have that wrong, Judge. We do have an internal report that was back.
That's what I'm saying. It's
Yeah.
already back.
Yeah, so we're not proceeding or with any.
That was just my note that you had been waiting on that, and I just
Yes, sir.
didn't have any update on it. All right. put it on Monday?
Yes, sir.
Mr. Lee, we'll see you back on Monday, March 2nd, 9 o'clock. Plea or continue.
Okay.
Thank you, Mr. Lee.
All right, good luck, Mr. Lee. I'll see you. Judge, give me just 1 minute. I wound up writing all over on this. Okay. Judge, he's got a case that's coming in for arraignment as well. I'd like to just keep all 4 of these together. I think we're going to have to do a global resolution on it.
So he's got these 4 and another one coming?
No, the 4th one, he doesn't actually get arraigned on, I don't think, until, I don't think he gets arraigned on it until tomorrow.
Usually wouldn't be on this docket, though.
There's not an offer on this case. I don't expect it to resolve with a plea. I'd expect it to just get resolved with a trial.
On all of them?
No, on the aggravated assault on specified personnel. That's what the state would go forward on first.
I don't see a new case. I think this is all 4 of them.
Now,
I mean, could be wrong, but
Could be wrong.
his name only got 4 open cases. Plenty of cases, just 4 open.
Judge, let me see here. I've got 2025-2115.
That's the one Mr. Sprouse is saying y'all want to try. 2115 is the aggravated assault specified personnel.
Yes.
Burglary, larceny, aggravated assault. Well, that's 3 of those counts and fleeing to elude.
And on the docket at 1:30 tomorrow is what my notes are. Now, that was based on the preliminary docket we got a couple of days ago. So. I've not had a chance to update with today's.
There's a direct file capias on the 2115 case from January 20th. But he's gone to first appearance for that. Okay. So it's really kind of a rearrangement on the same case.
Yes, sir.
So we were both right. There's only 4 cases, but it's still set on the docket.
Yes, sir. No, I was pretty sure it was only 4 cases. But at any event, let me go ahead and move to continue it then, and I will work primarily on the aggravated assault.
Did you say 429?
Yes, sir.
All right, 429 at 9 o'clock.
Thank you, sir.
Do we want to handle tomorrow's case? Do you want to enter?
I'm good with that. I told him that I would if the information been filed, since it's a direct file, that answers that question.
Submitted information was filed. That was a direct file for new counts, so.
I'll go ahead and enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions, and demand trial by jury.
And all cases will be set on 429.
Thank you, Judge.
All right, so you can take them off the docket for tomorrow. Thank you, Mr.
All right, no problem.
Yes, sir.
Okay.
Your Honor, This is Bryson Shanklin before the court on 25 CF 556. If you recall, last time we talked about trouble in getting an expert. The state did provide the name of one that they had no objection to. We did not get approval for that expert until Monday.
Approval from whom?
Pensacola.
Your office.
You use him. Yes,
Okay.
Your Honor.
Just one.
And we applied weeks ago. So we are needing to continue the case. We have more things that we need to do in regards to experts.
There's no objection from the state.
April 29th, 9 o'clock. Thank you.
Yes, Your Honor. If I may have just a moment with Mr. Thomas, and then I'm going to need to approach with Ms. Flowers.
All right. I'll just go ahead and turn.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
All right, for purposes of potentially a DPA, we're going to bring him back tomorrow. Do you want 9 o'clock?
Yes, sir.
All right, let's bring back Mr. Parnell tomorrow at 9 o'clock.
Yes, sir, we can do that.
You are a completely updated document like that?
This is the compel. Motion to compel.
Go back to like 2009 or something. It's like the app. Like, here's the extra page of all the people we threw on. That's how it used to be. I'm sorry about that. Go ahead.
That's all right, Judge. This is Benjamin Mack, 4625 CF 2022. Judge, Mr. Mack is first time up. We've not yet received discovery. I filed a motion to compel on it yesterday. I've talked with the state attorney about it. Apparently, the issue was with another agency, federal agency, and I'm sure the court recalls what that can be like dealing with them sometimes. So that's where we are.
I could probably still tell you about that.
Judge, Mr. Mack's in jail. I don't recall if he's there under pretrial detention. It is a trafficking case.
We had a bond hearing back on 12/4. That was denied.
What I would do, Judge, is at the least ask the court if it can reconsider that motion.
Trafficking over 400 grams of cocaine. So that's what, 400 grams is about a pound? It's a $50,000
And I
cash
think
professional.
28's an ounce. Or is it?
It is.
100 would be 40% of a kilogram. A kilogram is 2.2 pounds, so 40% of 2.2 is about 1, give or take.
Full candor to the court, Judge. We got our exhibit filed last night. The reports are very similar to another case where we have the feds and we have the county. Everything is on the county system. It's a new system. My CPD officer does not have access to that system. We are working diligently to get Mr. Mack and his defense what they need to prepare for trial. But unfortunately, we don't even have a witness list. All I have is the one CPT officer. Because the report, as Your Honor can see, doesn't say much.
I've always come to the same conclusion. It doesn't matter, but my conclusion is always, well, gee, Mr. or Mrs. U.S. Attorney, why didn't you just keep it?
Because it wasn't seized on a yacht.
Okay, so it's charged, the limits for the charges, it's over 400 grams, but the allegation is actually 722.
Correct. So it's the second highest level of cocaine trafficking. The other one is, I think, kilos?
It was actually a pound and a half. I think $50,000 is more than reasonable. I understand the concern, but file the motion to compel if you want to set that for a hearing.
My
We
understanding
can
is
even
it's
maybe
been
look
set
at
for a
next
hearing.
Thursday, and then you can ask me to revisit the bond. I'm not going to say what I'm going to do, but and whether or not I haven't really thought about it, is the fact that he doesn't have discovery. Is that a sufficient change in circumstances from the previous bond hearing? Because he's already had one, and that's
Yes.
why I bring it up.
Judge, I think it's set for 3-5. The motion to
The
compel.
motion to compel?
Yes,
All
I
So
think.
So do we want to put this on 4/29 and then also 3/5 for the motion hearing?
Yes, sir.
4/29 for the pretrial conference, 9 o'clock, and then March 5th. Want to put that at 9? I would
Yes,
say,
sir.
or put it in the afternoon.
I don't think it's going to be an issue, but
We're going to be here all day.
be here.
Judge, I don't know that it needs to go in the afternoon. It's simple. They've either given it to me or they haven't.
It was a simple request. Do you want afternoon?
I'd
or do you not?
say morning, but
All right, 9 o'clock, March 5th for the motion to compel.
Thank you, Judge.
thank you, Judge.
Thank you, Mr. Mack. We'll see you back next week.
Judge, this is William Matthews. He's got 2 cases. He's got a failure to register 25 CF 2248 that has violated his probation at 22 CF 2717. We have a bond hearing scheduled for him, I believe, tomorrow. It was mistakenly set today originally, and we had to shift it. I spoke with,
My big thing is I'm not sure if that was done on purpose. I just can't have stop for bond hearings on pretrials because we're here till 5 or 6 o'clock every time.
when I saw it, I was very surprised, but okay. I did not think that was likely either, but I thought that, anyway. All right, so, Judge, what I'm gonna suggest is we bring it back up tomorrow. I think once everybody hears what his mother has to say, that may help move things along.
Okay. Put it on for tomorrow. It's set for its bond hearing is that set at 2 o'clock, right?
Yes, sir. I'd have to check on that, Judge.
Pretty sure. I looked at them briefly last night about 11:15 after I emailed all the suppression orders around.
Yes, sir.
Looks like tomorrow afternoon's not terrible.
And just so the court will know, I'm not going to be ready to go on Krivic. We are getting some stuff back for his sentencing, but we're not ready yet.
Oh, Mr. Krivic?
Mr. Krivic.
I was wondering, because when I looked at that one, I didn't see anything had been filed, so.
The state would have no objection to continue.
Well, we'll address it tomorrow.
Thank you, Judge.
Yeah, we do have potentially a lot of pretrial detentions tomorrow, right?
Is that correct? Got 4? Because one was kind of just filed on.
Oh, it's set at 9 o'clock for tomorrow, the bond hearing. That's
All
fine.
right.
We'll just reset it tomorrow.
Reset it to 1, Judge.
No, for tomorrow, it'll be at 9 o'clock. It's just the bond hearing for Mr. Matthews, but I'm not gonna set a new pretrial until we get to tomorrow, just because if I set a new one now and then something happens at the bond hearing, they may.
Yes, sir. Yes, sir. I
Usually, yes,
understand.
I'd like to set another pretrial, but I just don't wanna have it set and then change it. I can always put it out there, if we start finishing before, 5 o'clock on these pretrials, maybe we could have a bond hearing every once in a while if needed, but.
Yes, sir.
I'm not keeping everyone here till 6:30 because we're doing bond hearings on pretrials.
Judge, this is James Mattingly, 25 CF 1642. Judge, I'm getting an expert to help me on this one.
What would you like, 4:29?
Yes, sir.
Mr. Mattingly, we'll see you back on April 29th at 9 o'clock. Let's make sure that your expert has helped you in time for that.
Yes, sir.
Okay, thank you, Your Honor.
Thank you, Mr. Mattingly. Have a good day.
All right, so Judge, I've talked with the state and talked with my client. There's a desire to get him into rehab.
This is Mr. McGovern.
Yes, sir. Mr. McGovern, Brian Lee McGovern, 25 CF 2064. So we're going to move to continue the case, and my investigator is going to see if we can get him in.
4:29, 9 o'clock.
Thank you, Judge.
Thank you.
Judge, I think this one can be resolved. There's been some discussion back and forth on a potential plea agreement. I need to take a counter to our counteroffer over to Mr. Millison and talk with him about it. It's not one that would get him out of jail between now and Monday, so I'd like to just bring him in on Monday.
March 2nd, 9 o'clock. Plea or continue?
I'll come out and see you probably Sunday, and I'll go over it with you, and you can decide if you want to do it.
So, can I hear what the offer is? I'm not just gonna lay down and get steamrolled, you know what I mean? Basically.
Mr.
Yeah.
Thank you, Mr. Millison. We'll see you on Monday.
Judge, this is John Nichols, case number 25 CF2337. Judge, we sent over an offer to the state. State's rejected it, but I might be able to resolve it with a B motion under what used to be 2.190. So I'm going to ask you to continue it one more time.
That rule still hasn't technically changed until, I think it's like July 13th, which is a weird day off for some reason.
I can explain it better, and this is my last case if we approach the bench.
Okay.
Okay.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, so what would you like to set it for?
Judge, go ahead and set it for 429. And Mr. Nichols, I'll explain to you what's going on, okay?
Mr. Nichols, we'll see you back on April 29th at 9 o'clock.
Yeah, I will, but not here on the record in front of the judge. Can you put him in the conference room for me? I'll come see you in the conference room. Judge, I think that's all the business I have.
That was the last one I had for you. I'm not sure if we skipped any. I don't think we did. Okay. So we're doing him next?
Judge Charles Russell, Public Defender's Office. This is Joseph Carroll, present and approaching. Case number for the record, 24 CF 2383. We have a bond hearing set for Mr. Carroll tomorrow afternoon. Depositions set in April, so we're asking for a continuance till April 29th on the pretrial conference, and then we'll be back tomorrow afternoon for the bond hearing.
Okay. All right, Mr. Carroll, you understand all that?
Yes, sir.
Okay. Mr. Russell can speak pretty quickly sometimes, so I just want to make sure. All right, then we'll see you back on 4/29 at 9 o'clock. And that depot is supposed to be in April. All right, thank you, Mr. Carroll.
Hey, Ms. Abrams. Got them ready to go on this file? Your Honor, this is Ms. Abrams before the court in several cases today.
Several.
Well, I guess I only am technically on one, 25 CF 2256, I believe, Your Honor. But this is a global resolution that would resolve all of her cases that are currently open before this court and before any other court.
What are the other cases?
26 CF 505, 24 CF 2753, 24 CF 2516, and 24 CF 1144, Your Honor.
The 2026 case?
I don't believe there's a 2026 case.
Did that say 2026?
25 CF 2256, 25 CF 505, and then the rest were 24s.
That's what I'm seeing. I think the first one you said was 2026.
If I did, I apologize.
That's not a big deal. I'm not upset. I just want to make sure I wasn't missing something. And those are all VOPs other than the 2256?
Yes, Your Honor. Can we lower this? Is there any way?
No.
Okay, you sure? All right. I'll just date it for you then. May I approach, Your Honor?
This is a downward departure as well.
Yes.
All right, Ms. Abrams, can you raise your right hand?
Yes,
You
sir.
Swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Ms. Abrams, you're here in a new case of felony petty theft. That's 25 CF 256. I got it. For some reason, I thought the numbers were transposed, but you had it right. I just want to make sure I was saying the right number. And then you've got 4 violations of probation. That's 25 CF 505, 24 CF 2753, 24 CF 2516, and 24 CF 1144. Do you understand all that?
Yes, sir.
I've been handed a plea agreement that calls for you to plead no contest to the new case and admit your violations of probation in the other 4. In return, it'd be an adjudication of guilt, credit for time served, and the new case, $515 court costs, $150 cost of defense. And the other ones, revoke and terminate your probation, credit for time served, adjudication of guilt, $100 VOP fee for each case, $100 cost of defense for each case, and all your costs to judgment. Do you understand that's potentially
Yes, sir.
suspend your driver's license if
Yes,
it all
sir.
goes to judgment?
I can't drive. Thank you.
Okay, I want to make sure I bring that up as a collateral consequence to your plea and the way it's set up.
Thank you, sir.
All right, and this is the state's agreement?
Yes, Judge.
Okay,
And it
and-
is a downward departure based on the negotiated.
Okay, and she scores 29.10 months in prison. You understand, Ms. Abrams, the only reason that you wouldn't be going to prison is because the state's giving you an offer to not do so.
Yes, sir. Yes, sir, and I thank you.
Don't thank me.
Thank you, ma'am. My daughter's coming to get me from West Virginia. I'm going back up there with her.
Okay, Ms. Abrams, did you go over this plea form with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
My one concern, Mr. Maddox, is this is a Although it's a violation of probation on 4 of them, this is a VOP plea agreement, so it doesn't go through all the trial rights.
I have gone through, I mean, not every single one, I guess that would supposedly be listed in the original plea form, but I can go through those with her now if the court would prefer. That'd be perfectly fine. But she's aware that she's waiving all of her defenses, all of her rights to trial, and she feels that this is in her best interest to resolve this case today, Your Honor. I can certainly rewrite it up on another plea form and go over it with her.
We can handle that, just
Okay.
make sure we go through them a little bit.
Of course.
All right, Ms. Abrams, did you go over this plea form with your lawyer?
Yes.
Did you understand and sign it?
Yes, sir.
Okay, one of the things that's not spelled out in here, I want to go through you. Do you understand that by entering a plea in the new petty theft case, that you're giving up your right to a trial?
Yes, sir.
Do you understand that means you're giving up your right to confront witnesses against you?
Yes, sir.
Do you understand you're giving up your right to subpoena witnesses on your
Yes,
own
sir.
behalf?
Yes, sir.
Do you understand you're giving up your right to have counsel present for you when you're going through your trial?
Yes, sir.
All right, and do you understand that you have defenses potentially, and you're waiving any of those potential defenses? Yes?
Yes, sir.
Okay. All right, and it's a time served offer, so. All right, are you satisfied with your lawyer's representation and advice in this case?
Yes, sir.
All right, are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
I do have mental health issues, but I'm not suffering from them right now, no, sir.
Okay.
I'm taking medicine.
You're taking medicine
Yes.
for that? All right,
Yes.
do you understand what's going on here today?
Yes, sir.
All right, so the medication you think is helping you?
Yes, sir.
Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement?
No, sir.
I've already talked to you about your trial, but do you understand if you admit your violation of probation, then there won't be a hearing where the state would have to prove that you violated your probation?
Right. Yes, sir.
Okay. And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
Do you understand that this new case is a felony that you'd be pleading to?
Yes, sir.
All right, and what is your plea to the new petty theft third-degree felony charge?
No contest.
Accept your no contest plea is freely, voluntarily, knowingly given. On the violations of probation, are you admitting or denying those?
Admitting.
I'm going to accept your admission as freely, voluntarily, knowingly given as well. In the new case, adjudication of guilt, credit for time served, $515 court costs, $150 cost of defense. In the VOPs, revoke and terminate probation. Credit for time served, adjudication of guilt, $100 VOP fee per case, $100 cost of defense for each case. All your costs will go to judgment. This is a downward departure as the state has announced based on an uncoerced plea agreement. You did score 29.1 months. I heard you say something briefly, it sounded like Ms. Abrams, about that you're leaving the state.
Yes, sir.
Okay. I've got concerns. If you come back in my courtroom with another charge like this, we're not going to be talking about time served.
Yes, sir.
I made that.
I appreciate that. I really do.
I mean, this is not a situation where you just can take anything that doesn't belong to you. I don't need a response, Ms. Abrams,
Yeah.
but this is not going to happen again.
Yes, sir.
All right.
Thank you,
I
Judge.
do need your fingerprints on
Oberliesen.
that new case.
Yes, sir. Thank you, Oberliesen. Mr. Oberliesen.
Judge.
Judge Oberliesen. I'm kind of nervous right now.
It's okay.
Better
I'm
each
not
time.
trying to make you any more nervous, but I just have to make sure you understand. You've got 5 cases in about a year.
I know, and I'm done. I was on drugs then. I'm not now.
That's all right. Ms. Abrams.
So, thank you.
Admitting you have a problem is the first step, Mr. Maddox.
Yeah.
Yes, Your
Thank
Honor,
you.
I understand.
All right,
Yes,
thank
blood,
you.
of course.
Thank you. I do need you to be fingerprinted and then
You gotta push me that way.
30 days to appeal.
Can I approach just briefly on an unrelated matter?
Okay. Go ahead, Mr. Maddox.
Yes, Your Honor, no problem.
Who do you have next?
Your Honor, this is Mr. Bell before the court in 25 CF 1498. I am asking for a continuance in this case, Your Honor. We're going to try and get this case into a position where we can take depositions, Your Honor. It's a case from 2021, Your Honor, so getting everything together and getting the deposition sets is going to take some time and some diligence, but we're going to try and get it in a posture where we can start getting those set, Your Honor.
You said it's from 21?
It is, Your Honor. Well, at least the incidents are alleged to have occurred in
Okay,
21.
that's-
Yes, Your Honor.
Well, I assumed, but I just wanted to make sure I wasn't
Yes.
looking at the wrong person. Well, let's get some depositions set, Ms. Leone, if that's what they're trying to do. Have y'all had contact with your alleged victims?
Oh, yes.
Or victim?
Absolutely, and that's why I was waiting for contact to schedule depositions and, yeah.
All right, sounds like that's going to be able to happen. So we'll see you back on April 29th at 9 o'clock. Get those depots set, and we'll see you back on that date.
All right. Thank you, Your Honor.
Mr. Boykin.
Still good on the plea?
About furlough though.
Okay, that's fine. Go ahead, sir, if you really want to address that. That's against my advice, but you're welcome.
Is this?
This is Charles Boykin, Your Honor, 25 CF 1524 and 25 CF 1525. I do believe we're going to have a resolution in the case, but Mr. Boykin would like to address the court.
Mr. Boykin, understand I'm not asking you any questions. Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, do you have some sort of voluntary statement you want to make to the court?
Yes, Judge Mon, I only got two questions. I got some business and stuff out there, like companies and stuff out there, and I want to know, could I get a furlough to handle my business before I go down the road? Cause I just came out from down the road from doing time, and I ain't had enough time out there to get myself prepared for, this issue, And now my mama died, my uncles and passed away since I was incarcerated, and I'm all alone by myself. And I'm up in age, and I ain't got no FTAs or nothing.
I understand, but you're not really telling me what you need to do. Tell me.
Oh, well, I'm trying to say, see, I got a bank right here in Crestview, and I'm trying to get to the bank because I can't notify my bank through the jailhouse because they won't accept no collect calls, and I don't have no money in my account to get to the bank. So I'm asking you, can I just get 2 or 3 hours, just enough to get to the bank and to get my business handled for my company and stuff out there? 'Cause I'm on the verge of losing everything.
Well, I understand, but from looking you up, you got out in February of 24. These offenses are from July.
I haven't been in no trouble since then.
Since when?
Since I got out. No more in there, no more in this, no,
Aren't
not
you in trouble right now?
Yes, sir, but that's not going, that was just not pouring in, sir.
Well, I understand. I mean, you did.
Yeah.
Judge, I mean,
It looks like a little under 2 years, but you've also been in prison for 15 years for sexual battery, armed burglary, 5 years for ag assault, 5 years for escape, 1 year for battery by a detainee, a year for bat Leo, and 6 years for a violation of your status as a sexual predator previously. So based on all that, why would I let you out? Because you say something vaguely about a bank account that you have.
Yes, sir,
that makes you a flight risk. That makes you a potential danger to this community. There's a reason you're sitting there without bond, right? Any other requests, Mr. Boykin?
No.
I'm not trying to be difficult, but I think to grant such a request, would not be a wise decision by the court.
All right.
We appreciate the court's consideration, Your Honor.
And frankly, I want to make sure I told you this before I accepted a plea, and then you asked for it, and you feel like
I
you're kind of
did.
hemmed in. But if you'd still like to go forward with your plea, you're free to do so.
Don't want to go forward with the plea? Okay, sir. Judge, just one thing I do want to address quickly so that Mr. Boykin does have an answer on this. My understanding is that he was held in Alabama and then transported here, and that he did time only in relation to this case on this hold dating back to June 2nd of 2025. My understanding is that the court can award that time. My understanding is it is a discretionary award from the court. However, the primary consideration is whether the hold was the only thing that's holding him for charges in the state of Florida, and it's my understanding that it was. I don't have anything else other than a proffer today to the court that is the situation. If the court needs something more definitive, I can certainly get paperwork for that, but that was Mr. Boykin's only other concern.
I need some paperwork on that.
Yes,
I can't
okay.
just say, he said he was there. I'm not saying I won't give it to you, but I have to have the paperwork from a
Want
different.
me to get that before you enter the plea? Okay. Ms. Leone, any objection to me tracking down that paperwork before he enters the plea?
For how long?
Oh, just March 2nd. I'll get just called to jail and, figure out,
Jail where?
In Alabama where he was held. Sure, I can. I'm sure I can get something.
You're very optimistic that you're going to get a sufficient response from another jail. I'm not saying it's not going to happen, Mr. Maddox. I hope it does for you. But
Well, and I mean, even if not, I could probably
doesn't.
address it on the back end. Mr. Boykin was asking me to look into it, and I did.
certainly.
Yeah, 3-2, then, Your Honor, we'll try and get this done. Thank you, Ms. Leonard.
March 2nd for a plea or continuance?
Yes, Your Honor.
Okay.
Yes, please.
Your Honor, could we set Mr. Brand for March 2nd for possible resolution? The state was looking into a possible offer that my client would be interested in taking. We may be able to resolve it then. I would ask it's a plea or continuance. We did get the depositions done in this case, Your Honor, so it is in relatively good position. The only thing I'm still waiting on was a mitigation report that I requested from Dr. McDonald, but if the state does make an offer that my client wants to take, then we'll go ahead and resolve the case without that.
All right, March 2nd, plea or continuance.
Thank you, Your Honor.
Mr. Sprouse, can you come back up about the order you were asking about? Probably just better off doing one on the big case and the other one. But also make sure it's in there, because I haven't had a chance to look it over at all.
Your Honor, we're going to have a resolution in this case. It's going to be 3 years.
this?
This is Mr. Bernett, Your Honor, 25 CF 783.
And since I'm standing up, can we approach just briefly?
Sure.
Thank you.
Same thing, nothing changed in there. Just explaining to the judge the reason for the plea. May I approach? Your Honor, if I may, real quick, Mr. Bernett was asking if the court would award any discretionary time that it could while he was awaiting to be transported from the Department of Corrections to here. In full candor to the court, however, he was still serving a sentence that he was previously serving while there. Although there was a hold in place, a detainer was lodged against Mr. Bernett.
Is he still serving that sentence?
No, Your Honor, that sentence has been served. The prior sentence has been served. However, I do believe that the hold was consistent with that sentence being served and then that he was transported here. I don't think there's, I think it was all overlapping.
Just to make sure I understand, the request is that while he was in prison, he's charged with trafficking methamphetamine in the prison, and he wants to get credit for time served on the previous sentence put onto this one while he was waiting this detainer.
Candidly, yes, Your Honor.
No.
Understood. I understand the reasoning.
What is the motivation for not trafficking methamphetamine when you're in prison then if you just get concurrent time?
I understand, Your Honor.
But again, Mr. Bernett, I'm saying that before I accept the plea, so you understand that the court's position is I'm not going to give you any time served from when you were serving another sentence and then committed this crime. And I'm basing that on the fact that you said you're pleading. I'm not making any sort of factual finding that you have committed it.
Yes, sir.
Because you haven't taken that actual plea yet. But the allegation is that you were trafficking methamphetamine while in prison, so I'm not going to give you basically double credit.
Yes, Your Honor. Understood.
Based on that, do you still want to go forward with the plea, Mr. Bernett?
Yes, sir.
All right, raise your right hand. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Anthony Scott Bernett, 12/4/78.
Okay, Mr. Bernett, you're here in 25 CF 783, where you're currently charged with trafficking in methamphetamine, 28 grams to 300 grams. That's a first-degree felony and punishable by up to 30 years in state prison, a $100,000 fine, and a minimum mandatory of 7 years. You also have count 2 as an introduction to contraband, which is a second-degree felony, punishable by up to 15 years in state prison, and a $10,000 fine. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would have you plead to count 1 only and to a lesser included offense. It's still trafficking, but it's a lesser level. So that's trafficking 14 to 28 grams of methamphetamine. It'll be a minimum mandatory 3 years Department of Corrections with credit for all time served. And that served, since you were served with the warrant and detainer to come back here, it's a $50,000 fine, adjudication of guilt, $1140 in court costs, $150 cost of defense, and all of your costs to judgment. Count 2 would then be dismissed by the state.
That is correct.
All right, and this is also a downward departure. The state has given its reasons for its uncoerced plea bargain up at the bench.
Yes, Your Honor.
All right. Is that what you want to do today, Mr. Bernett?
Yes, sir.
Yes. All right. Did you go over the plea form with your lawyer?
The plea form that we just signed?
Yes, sir.
Okay. Did you have enough time to do so?
Yes, sir.
All right. Are you satisfied with your lawyer's advice and representation in this case?
Yes, sir.
Okay. And you understood and signed the plea agreement, right? That's your signature?
Yes, sir.
Okay. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
You currently suffer from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
All right, and has anyone promised you anything other than the terms of the agreement between you and the state that I just read to you?
No, sir.
All right, and do you understand by entering this plea there won't be a trial of any kind?
Yes, sir.
Do you understand that you're giving up your trial rights, which are listed on page 2 of that agreement that you've signed?
Yes, sir.
And do you understand that you're waiving all potential defenses?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation and or exclusion from the country?
Yes, sir.
And what is your plea to the lesser included trafficking of methamphetamine 14 to 28 grams?
No contest, sir.
I'll accept your no contest plea as freely, voluntarily, knowingly given. 3 years Department of Corrections. It's a minimum mandatory sentence with credit for time served since you were brought over on your detainer. $50,000 fine, adjudication of guilt, $1,140 in court costs, $150 cost of defense. Those costs will go to judgment. This is a downward departure, again, based on an uncoerced plea bargain. I need your fingerprints, Mr. Bernett, and then you have 30 days to appeal the judgment and sentence.
Thank you. Thank you, Your Honor.
Good luck, sir. All right, man.
Judge, just so the court's aware, we're going to ask to bring Mr. Nichols back out, reset him for the second. We may be able to get the case resolved on that date with the court.
Which one was Nichols?
Jonathan Nichols, that was the one where I said I might bring a motion under.
The B motion.
Okay.
I don't have a cane. I don't know anything about cane.
Hey, Mr. Kamarda. Your Honor, this is Mr. Kamarda before the court in 25 CF 1806. Your Honor, I am waiting for a competency evaluation to come back on Mr. Kamarda. Also, Your Honor, I did file a bond motion. I don't believe there's going to be time now to set that for tomorrow, and I want to make sure the state is properly notified. So if we could do that on March 5th, that would be fine, Your Honor, and I'll file a notice of hearing.
An issue with tomorrow?
I have no issue with tomorrow. I understand what the
Okay.
evidence is. I already
That's fine then.
looked at it.
We'll
I
hear
think the
tomorrow.
notice requirement's 3 hours, and I haven't
Oh, it's
checked.
3 hours, okay. I thought it was longer than that off the top of my head.
I think
Okay,
it's
that's
3
fine.
hours unless it's changed.
No, that's fine then. We'll hear it tomorrow.
All right, then we will have your bond hearing tomorrow, sir.
All right, thank
And then
you.
otherwise, we're setting him for April 29th on his
Yes, Your Honor.
pretrial.
While
All
we
right,
wait the
April
evaluation.
29th, 9 o'clock for pretrial, and his bond hearing will be tomorrow. Let's put it in the morning, 9 o'clock.
That's fine, Your Honor.
Thank you.
Put it on the add-on list.
See you tomorrow.
All right,
You're good,
thank you,
sir.
thank you.
All right, man. Hey, sir, how you holding up? All right.
Somewhat.
I understand. Your Honor, I'm still waiting. This is Mr. Carpenter before the court in 25 CF 1405. I'm still awaiting Mr. Carpenter's second evaluation from Dr. McDonald based on the concerns that I raised last time with the court. I will check with her on the status of that.
What would you like to do with the case in the meantime?
I'd ask to continue it, Your Honor, to the next pretrial.
How long is it?
All right, Mr. Carpenter, we'll see you back April 29th, 9 o'clock.
This one's getting old.
Thank you.
I understand, but you're waiting on an evaluation. It's, unfortunately, we're just getting kind of backlogged on those. Over in Escambia last week, I think half my hearings were competency hearings.
Stay out of trouble.
No,
Be good.
Kamarda.
Yes, sir.
Okay. Judge, we're going to have a resolution in this case. I'll write it up.
All right, we'll bring you back, Mr. Carter, once he's written that up and talked to you about it.
Thank
But
you.
you'll come back later today.
Thank you, ma'am.
Hey, Mr. Conway.
I'm doing okay, sir.
Hey, good, sir. Oh, do I give you Mr. Conway, Ms. Flowers?
Yes, I've got it.
Your Honor, we're going to have a resolution. This is Mr. Conway before the court in 26 CF 15 and 26 CF 129. If I may approach, Your Honor.
29.
Yes, Your Honor. It's set to be arraigned tomorrow. Information has been filed.
All right, Mr. Conway, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
All right, Mr. Conway, can you state your full name and date of birth, please?
Brandon Mendel Conway, August 28, 1980.
All right, Mr. Conway, you're here in 26 CF 15, charged with possession of a controlled substance, third-degree felony, punishable by up to 5 years in state prison, and 26 CF 129, lewd and lascivious exhibition, which is also a third-degree felony, punishable up to 5 years in state prison. Do you understand that? Mr. Conway, I've been given a plea and sentencing agreement that would have you plea as charged in both cases and be credit for time served, adjudication of guilt, so that's 2 felony convictions.
Yes, sir.
You can put your hand down. $150 cost of defense, and, well, shouldn't it be
Oh, it should be 150 and
then-
100, yes, Your Honor.
Okay,
That
100
changed
and
your decision.
150 for a total of 250. It says 515 court costs, but are they both 515 or each? Okay. So
Oh, because of the drug charge.
615 on the L&L exhibition? Oh, that's not a drug charge. Okay.
That changed your decision into the plea. That is significantly more money than I wrote on the plea form.
615 court costs doesn't change your decision, Mr. Conway?
No, it doesn't, Your Honor.
Did you say 817? 817 on the 129 case. Have you had a chance to go over this agreement with your lawyer?
Yes, sir.
Okay, did you have enough time to do so?
Yes, sir.
And did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently suffering from any mental health issues?
Not that I know of.
Okay. Do you know what's going on here today?
Yes, sir.
Okay. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
I think only one of the cases is on the score sheet. That's the possession of controlled substance, but there's no, the L&L charge is not on there. It's a level 1. It's not going to really change anything, but I'd rather it be accurate.
Yes, sir.
All right, I want to continue to go through it while they fix that.
do it.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I've just talked about?
No, sir.
You understand by entering a plea, there won't be a trial of any kind?
Yes, sir.
You understand that means you're giving up your trial rights, which are on page 2 of that agreement that you've signed?
Yes, sir.
You understand you're waiving any potential defenses that you may have?
Yes, sir.
And you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and what is your plea to the 2 counts, possession of controlled substance and lewd or lascivious exhibition?
No contest.
Accept your no contest plea is freely, voluntarily, knowingly given. It's going to be time served, adjudication of guilt, $150 and $100 for a total of $250 in public defender fees, $615 on the possession charge, $817 on the L&L exhibition charge. What do you want to? Do you want time to pay that?
90 days, Your Honor, we'd
All right,
request.
I'll give you 90 days, Mr. Conway, to set up a payment plan or pay those court costs off.
Yes,
With
sir.
the clerk of courts. I do need your fingerprints, because they are felony convictions, and then you've got 30 days to appeal the judgment and sentence of the court.
Yes, sir.
I don't have the guidelines back, but I believe it's a guideline sentence still. Very minor change, but I just want to make sure that it's on there. All right, so you ultimately scored 29.9 points. So there's no presumptive prison sentence. All right, thank you, Mr. Conway. Have a good day.
Yes, sir. You have a blessed day, sir.
Mr. Cooper.
Hey, Mr. Cooper. All right, man, right here. Your Honor, this is Mr. Cooper before the court in 25 CF 2245. Your Honor, we have filed for competency. I don't know if I did a motion order off the top of my head, but we're awaiting a competency report, Your Honor. I do believe he's going to be incompetent, but we'll see. It is the first time up, Your Honor. I'll ask for a continuance to the next pretrial. Okay.
Looks like the order was signed on January 11th.
Okay, I'll follow up on it.
April 29th, 9 o'clock.
Thank you, sir. You're good.
I'm going.
No, unfortunately not, but you're good to go here. You didn't plea. You didn't plea. There's no plea. Mr. De La Rosa. Saw your Nelson hearing. We'll get set for a hearing. Go ahead, sir.
What do I got to say?
Your Honor, this is Mr. De La Rosa before the court in 24 CF 1700. I did go back and review the court file. I do see now that there it hasn't been a Nelson hearing filed. He's welcome to pursue that. That's his right. So I guess I would ask the court to set that for a hearing. I suppose we could do it. I have a lot of cases to prepare for tomorrow. I would like to look over it at least, Your Honor, if we could do 3-5.
All right, we'll put it on tomorrow, or not tomorrow, on March 5th at 2 o'clock. The Nelson inquiry. Otherwise, we'll continue the case till April 29th at 9 o'clock for pretrial.
Thank you, Your Honor.
That's my expectation, is I'm not going to continue it again. I mean, obviously, we have to go through the Nelson inquiry, Mr. De La Rosa, but that could change things. But if Mr. Mannix is still your lawyer, I expect this to go to trial next time.
Okay.
Thank you.
Denman.
Yes, sir.
Mr. Denman. Your Honor, this is Mr. Denman before the court in 25 CF 1343. Your Honor, Mr. Denman did just recently pick up a new charge. It's possible that we'll be able to work them out together. It was brought to our attention actually in deposition, so Mr. Sprouse and I will get together on it. It's possible to be able to work something out on it, at least based on some of the conversations we had early on. As for this other case, Your Honor, I do know it's getting old. We have taken the depositions in the case. We could probably be prepared to try it if need be next cycle. So I would ask for their continuance, but if we're not able to work something out, assuming I have discovery in the new case and I'm able to make a proposal to Mr. Sprouse that would suit Mr. Denman, I could be ready for trial.
Is the new case here?
It should be, Your Honor, 26 CF 288. Florida.
There it is.
I don't see him on the docket for today.
It's not on the docket. I'm just taking a look at what it is. It's fleeing to elude as well.
No, that new case, that new case is not.
I don't see him on.
No, it's set for arraignment on the 26th of March. I was just wanted to see what it was and make sure that's actually there.
I think the
Hold on.
court.
I think an information's been filed.
I would doubt it's.
I have-
Arraignment's 4 weeks from now. I don't.
Oh,
see
you said
one.
326.
326.
I'm
not
sorry,
tomorrow.
I thought you said 226.
So what do you want to set this one for?
The next pretrial conference, Your Honor, with the expectation that if we don't resolve everything, that, we could be ready for trial.
4/29, 9 o'clock. Set for trial, so this will be the last continuance on this case.
Yes, Your Honor.
Can I get the case number, please?
The new one?
The old one.
25 CF 1343.
It wasn't on my docket.
I wouldn't be surprised.
Yeah, he may have been on Monday's docket being out of custody because then the new charge came.
Oh, yes. Yes, that's probably what it was, Your Honor. All right, sir.
Probably on the updated docket. It was on mine.
Mm-hmm. Your Honor, this is Davin Smelly before the court on 25 CF 1730, 25 CF 2247. We have begun the deposition process. However, we are not completed on that yet. We still have depositions to do in 25 CF 2247.
Asking for?
Yes, Your Honor, I am asking for continuance to 4/29/26 if the court's so inclined.
All right, April 29th, 9 o'clock, Mr. Smelly.
Love you.
See you back on that date.
Sorry about that, Judge. This is Mr. Dunmore before the court, 25 CF 1078. I would like to talk with Ms. Flowers about this case, Your Honor. If we could set it for 3-2 for possible resolution. I also have a bond motion that's been filed, Your Honor. We can hear that tomorrow or March 5th, whichever would be the state and the court's preference.
It's been filed, I don't.
Okay.
Do you have a case number?
I do. 25 CF 1078.
When was it filed?
The bond motion, Your Honor? I want to say I filed it Friday.
See it.
I filed a notice of confidentiality since I filed medical records with it.
Hasn't been processed where I can see it yet.
Okay, I'll check on it. I got a response back from the clerk on the notice of confidentiality, so I will check on that.
So everyone understands when the clerk gets it and they say, yeah, we got it, they still have 72 hours to process it.
Sure, and that's fine.
So that means I can't see it until,
If I have time today, I'll print a copy and give it to the court and give it to the state.
email it to my assistant.
Or
It's
email
fine
it.
too. It's
That's-
just, I don't get e-served like y'all do.
Yes, Your Honor.
Otherwise, I would get, 1,000 things a day.
Yeah, it'd be miserable.
So just when it's something that we wanted to go quickly on like this, just make sure you send me a copy so I can read it.
Yes, Your Honor.
All right. All right, Mr. Dunmore, I guess we're going to see, y'all want to put it on tomorrow?
That would be the plan,
For
yes,
the
Your Honor.
bond?
I believe the state's ready.
All right, but we want it on March 2nd for plea or continuance?
Yes, Your Honor.
All right. March 2nd for plea or continue, bond motion to be held tomorrow at 9 o'clock.
Thank you, Your Honor.
Yeah, at 9 o'clock?
Yes.
Enzenbacher.
Enzenbacher. Your Honor, this is Mr. Enzenbacher before the court in 23 CF 1532. We're just trying to get depositions set in this case, Your Honor. We have reached out to the state. We're just waiting on dates back. Again, I know there's been a lot of transition. We just need to get the depots set, Your Honor.
April 29th, 9 o'clock. I know it's an old case. I know why it's an old case, but let's try to make it more of a priority.
Yes, Your Honor.
I looked at this case probably at like 2 o'clock in the morning. So what I have is that he's not competent to proceed.
No, he
I
was.
think he's back from the hospital.
Correct. He came back. He was ruled competent to proceed.
Okay.
I
I'm
may
on
have
the
even
same
had
page.
him. I don't remember at this point. I may have even had him evaluated again before we had that hearing. I don't recall off the top of my head, but I don't have any concerns at this point.
So 429.
429, yes, Your Honor. And I will make every effort to
Sorry.
get depots set before that conference.
I wrote it down. I don't think I said it, so that's why y'all were waiting. Go ahead.
Hey, Mr. Fiducia.
How you doing, sir?
Your Honor, this is Mr. Fiducia before the court today in 25 CF 631. We do have a resolution in that case, Your Honor. If I may approach.
Mr. Fiducia, raise your right hand. You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your full name and date of birth, please.
David Anthony Fiducia, September 6, 1968.
Mr. Fiducia, Fiducia, you're here driving, charged with driving while license suspended or revoked, third-degree felony, punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
Have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Calls for you to plea as charged, adjudication of guilt, which is a felony conviction, $515 in court costs, $150 cost of defense, and those would go to judgment.
Sure.
Is that what you want to do here today?
Yes, sir.
Did you understand the agreement and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice?
Yes, sir.
Anyone forced, pressured, or threatened you in any way to enter this?
No,
plea?
sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you suffering from any mental health issues?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just announced?
No, sir.
You understand if you enter a plea, there won't be a trial?
Yes, sir.
You understand you're giving up your trial rights, which are on page 2 of the agreement you signed?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and what is your plea to the driving while license suspended or revoked felony?
No contest.
Exception, no contest plea is freely, voluntarily, knowingly given. Adjudicates you guilty, credit for time served, $515 court cost, $150 cost of defense. Those will go to judgment. This is a guideline sentence, as you scored 27.8 points. I need your fingerprints, Mr. Fiducia, then you have 30 days to appeal.
Yes, sir.
Judge, my client is asking to set this case for trial. I've discussed my concerns about that with
Mr.
him.
Maddox, can I stop you?
Yes, sir.
Who's your client?
Your Honor, this is Mr. Fonseca before the court in 25 CF 1972. Your Honor, I haven't taken any depositions in this case. I do believe there may be some additional body camera footage that exists in this case that I'd like to track down. I've shared those concerns with Mr. Fonseca at the jail. He had indicated that he was fine with the continuance. Now he's asked me to set the case for trial. I can be ready for trial with what I have, but I'm not nearly prepared as I could be. If he understands those risks and he still wants to go to trial, I've talked to him about the case. I've talked to him about the maximum he could get. I've talked to him with my concerns about the case. I've gone over the jury instructions with him. So I can be ready to go on this case, Your Honor. I don't think that's the best thing for him to do at this time, but he's the client. If he wants to go to trial, we'll go to trial.
State. Fonseca.
That is fine.
Does the state have an offer for him to consider in lieu of that? I'm not sure I've actually been given one in this case. Of course.
I would have to get back with you. This is a
Okay.
animal.
Well, we'll have it. Yeah, it's an animal cruelty case. I know you guys have to go through Pensacola.
Correct.
Yep. So,
All right, Mr. Fonseca, do you want to set your case for trial?
Sir?
Do you want to set your case for trial?
Yes, sir.
Do you understand that you're charged with 7 third-degree felonies for which you could get 5 years in state prison each?
I didn't hear that last part, sir.
You understand that you can get 5 years in state prison for each of those charges?
Yes, sir.
And you've heard your attorney announce that he's got more work to do before he feels that he'll be prepared for trial?
Yes, sir. My concern, and I've tried to discuss this with him, is the fact of culpable. He's caught up on that, and he handed me some paperwork yesterday.
the jury
Under-
instructions.
Right, under culpable. I don't feel that my case falls under that, sir. And again, I have no offer. Nothing else has been moved.
That much is true.
I mean, nothing, I haven't been told anything. I've been in jail for 5 months, sir. I feel that at least going to trial, I'll have something done.
And do you understand you get one chance at trial, right?
Yes, sir.
You want to go forward even though your attorney is saying he hasn't done everything he'd like to do before trial?
Oh, how much longer do I have to wait,
I'm
sir?
not
Oh,
asking,
I'm sorry.
I'm not
I'm
trying
sorry.
to convince
Right, I
you of
understand.
anything. I just want to make sure you understand what you're doing here today.
That's until April. Like I said, the April pre-trial conference.
And what happens
I'll
at
set
April?
depositions before then. And
Any sooner?
no, sir, no, that'd be the trial cycle.
It'll be late April.
But the
So-
pre-trial conference would.
Oh.
Judge, after discussing it further with my client, we're not going to set this case for trial. My client does agree to have the case continue until the next pretrial conference. I will make every effort possible to have this case ready for trial, as he clearly wants to go to trial.
Okay, Mr. Fonseca, just a couple of quick questions, kind of
Yes, sir.
following up on that.
Yes, sir.
Do you feel as the court has somehow forced or pressured you not to go to trial this time around?
No, sir, I'm just concerned about verbiage, and the charges. I think they're a little more severe than.
Well, I understand that.
No, I'm
I'm
just saying, and I just want an answer, sir. That's all I'm asking for, because I haven't had any.
Well, you
Well-
have it. Quite frankly, Your Honor, we disagree on how the law applies in this case and exactly how things are going to shake out. at least
May I
based on
read,
what we have.
may I read something, sir?
That's all I
This
want.
is not a
That's
trial.
all I
Okay,
Okay,
want.
I'm sorry, I was just going to say.
All I'm trying to find out is
I
if you
understand,
feel
sir.
like, Mr. Fonseca,
Yes, sir,
slow down.
sorry.
I ask you a question,
Yes,
it's
sir.
because I want to know what the answer is.
Okay,
I'm not trying to have you jump over me and say, oh, no, I got it, and you're doing it now. I know you're doing it now verbally, but you're,
sorry.
you're making head gestures and just hold on a second.
Yes, sir.
Take a breath. Okay. Do you feel that what I've asked has coerced you in some way to say, no, I don't want to go to trial right today?
No, sir.
All right. Do you feel is there anything that Mr. Maddox has discussed with you has been some sort of pressure to not go to trial yet?
No, sir.
April 29th, 9 o'clock.
Thank you, Your Honor. I'll come see you tomorrow.
Yes, sir, thank you.
All right.
Thank you.
Yes, Your Honor. This is Ms. Samantha Forest before the court in 25 CF 1573. Your Honor, the state has tendered me a new offer for Ms. Forest. I'd like to go over that. In fact, actually, if we could set it for 3-2 just for a plea or continuance situation, Your Honor. I have taken depositions of some of the AVs in this case. If she does decide to go to trial, I probably will need to depose Jameson, who is the child involved here. And I don't believe I got a chance to depose the officers because they were set a little bit late and we were coming up on, the office closing. So I may have to reschedule them as well. But we're in pretty good shape in this case, Your Honor. Some depositions have been taken. I'd like to go over that new offer with her. If we could set it for 3-2 for possible resolution.
So I will say that the offer takes into consideration the child not being deposed. So if you're gonna,
Okay, fair enough. Then I'll keep that in mind.
You're handling the case, Mr. Sprouse, even though there's a child abuse charge?
That's correct.
It's been, yes, Your Honor, it was in the division even before.
Okay.
Because the main charges are.
I just want to make sure, because usually it's
Yes, thank you.
y'all
Your
on that
Honor.
side of the table who are handling those. All right, we'll see you back on March 2nd. That's Monday at 9 o'clock.
Come talk
Clear
to you.
continue.
Yep.
Mr. Williams, are you ready on Nichols?
Yes, sir.
Pass around snacks, what's going on?
Yes, sir. This is John Nichols. We had called him up earlier. He has, we've since talked. We're going to leave it on for a possible plea on Monday. Case number on it's 25 CF 2337.
Had we done with it earlier?
We set it for 429.
All right, so Mr. Nichols, we're going to put on for plea or continuance on Monday, March 2nd.
Thank you, Judge. All right, Mr. Nichols. And Judge, with that, if I can be excused.
Yes, sir.
Thank you.
Have a good day, Mr. Williams.
All right, this is Mr. Foster before the court in 25 CF 2026. Your Honor, I am asking for a continuance in this case. The case is very likely to need depositions based on everything that I've gone over in the case, Your Honor, so I'll try and get it postured and get those set.
April 29th, 9 o'clock. Be back on that day, Mr. Foster.
Thank you.
Green.
Ms. Green. For the court in 25 CF 1817 and 25 CF 494. Reached out to the APD, Your Honor. I know the court signed its order in January. Based on my conversations with the APD, they have not done the evaluation yet or really made any efforts to set it up. I believe there was an issue with them getting the order. I have reached out to Mr. Sanchez, who is my contact, provided him all the information he requested, and if possible, told him to expedite it. I'm hoping that they will be able to expedite it, but I'm making every effort to make sure she gets evaluated, Your Honor.
So what are you asking for?
A continuance, Your Honor, based on the circumstances to the next pretrial conference, or to March 26th. I believe that would be a miscellaneous date if it would please the court.
Just put it on 429, and then you can move it up if you get everything you need.
Yes, Your Honor.
All right, thank you, Ms. Green. April 29th.
Guzman, Arredondo.
Your Honor, this is Ms. Guzman Arredondo before the court in a few cases.
Oh, no.
Your Honor, I'd like to set the case for March 2nd for possible resolution. I did have a plea agreement that we thought we had worked out, but Ms. Flowers would like to double-check the score sheet based on some issues she brought to my attention, Your Honor. Assuming it checks out, then we'll enter the plea. Assuming it doesn't, I don't know that it would shift much. I think we'll still have a resolution.
On Monday?
Yes, Your Honor.
March 2nd, 9 o'clock.
I'll come see you.
Thank you.
Thank you. See you Monday.
Your Honor, this is Ms. Munda before the court in 24 CF 2820. Your Honor, I was still awaiting Dr. McDonald's report, or Dr. Zeman's report, excuse me, in this case. She's now in the jail, unfortunately, because her bond's been revoked and she's picked up a new charge. We may be able to resolve that charge with this charge, Your Honor. I believe it's a violation of injunction. I am asking for a continuance based on my awaiting of that competency report. I will let Dr. Zeman know that she's now in the county jail.
May I please speak, address the court?
Hold on just a second.
Vince.
What would you like to do?
I'm asking to continue this case, Judge, based on my
please.
awaiting for the report. I have to wait for the report. I've had concerns about your competency for months. I'll have Dr. Zeman come out and see you in the county jail.
Sir, I'm saying I have already met with them.
No, you haven't. With Dr. Zeman? Go ahead.
Your Honor, I've had mental continuing.
Hold on, let him swear again.
Hold on. I'm not sure what I've done to upset you, Miss Munda.
You're nothing.
But
I'm
then
just
I
at
would
the whole
guess
situation.
It'd be a better idea that you don't yell at me to start off.
I'm not trying to.
Try harder. What would you like to address?
Your Honor.
I don't need the hard squint either. Like I've
Okay,
done
I'm
something
sorry, I
to
don't have my
offend you.
glasses on. Your Honor, I've had mental health evaluation after mental health evaluation
I understand that,
continuously.
ma'am. This is about competency. It's a different type of evaluation done by a different type of person.
Sir, I was not served because
Don't
since
talk
my,
about the facts of the injunction case.
I was not served the paperwork.
Well,
Since my
I understand
divorce.
you're saying that, Miss Munda. However, I'm looking at that misdemeanor case number where you were served in open court. with
I'm
that
served where?
paperwork. So we're not going to talk about the facts of the case. But what I'm reading is that a deputy who works in this courthouse is the one that gave it to you in a courtroom. So I'm not sure what else there is to say about that.
Can we run it concurrent and I get probation?
Look, if you're competent to proceed, sure. If
Okay,
there's
I'm-
an offer you'll take, yes.
Yeah,
I don't
I'll
have
take
the
an
report.
offer.
Respectfully, I need the report. I've got to get the report from Dr. Zeman, who's going to come out to the jail and see you. I know it's frustrating. I know you don't want to be in the
Why
jail.
is there a competency request
I'm not
anyway?
going
No, I don't.
Your Honor, I've got nothing
right
further
now.
for Miss Munda. I'll go see her in the jail. I understand. I understand.
429, 9 o'clock.
If I may, Judge, Cordell Thomas was addressed earlier,
Yes.
correct? Okay.
We dealt with Mr. Thomas.
And then Kenneth Kane, he hasn't been transported here in quite some time, but he's just awaiting his second evaluation. That was at the state's request, Your Honor. I would just request a continuance to 429 on that case. I believe that is being done by Dr. McDonald.
That's Morrow.
Sorry, Your Honor?
That's Morrow that you're talking about?
Kenneth Kane, Your Honor.
I don't have Kane.
I don't know why he's not on the docket. I have it written down that he should be set for today.
What's his case number?
25 CF 782, Your Honor. I mean, he never gets transported due to the situation, but
782?
yes, Your Honor, 25 CF 782.
Kenneth Kane.
Yes, Your Honor.
signed the order January 2nd.
Yes, you did.
He was found incompetent.
Correct, he was, Your Honor. And what we were concerned with is whether he's restorable or not. Yes, Your Honor.
Is he still in the jail?
He is, Your Honor.
He's not on the docket, but put it on 429. Let's make sure it's on 429, and we'll deal with it. If you get the evaluation back, we want to have a hearing
certainly.
earlier than that, please set it.
Yes, Your Honor. And then same thing with Mr. Berryman Green, Your Honor, 25 CF 2292.
Can we address that?
I believe we did. I just wanted to make sure it makes the record.
Y'all have that done already? Oh, okay. So what are we doing with Green? I know we talked about it.
A continuance based on us awaiting the report. There, candidly to the court, Your Honor, there's been some difficulties in obtaining his cooperation. Or actually, heck.
April 29th, 9 o'clock for Berryman Green. We talked about it, or I thought we had resolved it. Not resolved it, but handled it. Anything else from Mr. Maddox?
Shouldn't be, Your Honor. That should be everything. That I am going to do, yes. All right.
Your Honor, this is Shane Morrow before the court on 21 CF 2674, 21 CF 2998, 22 CF 273. And speaking with him the other day, he said he's filed for a Nelson hearing.
When do you think you filed it, sir?
Actually, to be honest, I have not filed it. I have it with me right now. I was going to see if I could file it in the courtroom. I have 2 copies prepared.
Just mail it in,
Okay, yes, sir.
and then we'll get it set for a hearing.
Yes, sir.
Your Honor, taking that into consideration, we request continuance to 4/29/26 until such time as the hearing can be held.
I'm sure we'll have a hearing before then, but I have to have it filed, and everyone has to take a look at it before I can set it for a hearing, Mr. Morrow.
Yes, sir.
So in the meantime, your next pretrial is going to be 4/29 at 9 o'clock. And then what typically happens, once you get that file, the copy goes to me, and then I tell them to set it for a hearing,
Okay, sounds good.
assuming it's legally sufficient. All right. Thank you, Mr. Morrow.
Thank you, Your Honor. Thank you.
Mr. Osborne.
Your Honor, this is Kenneth Osborne before the court on 16 CF 1542. And speaking with Mr. Osborne the other day, he has pneumonia. Yeah, so he's not feeling his best right now. At this point, we are going to ask for continuance to the 4/29/26 docket.
I have drafted the order on his motion to suppress on the warrant issue. I am denying the motion. Again, I finished that last night, and it's in my queue now to sign. So again, you'll probably have it either later today or tomorrow, just based on how long we're here.
Thank you, Your Honor.
The gist of it was, I believe, because of it's a Scrivener's error on the video voyeurism statute. It's 817 instead of 810 is what it should be, but it still spells out video voyeurism on the actual warrant. And then the second issue was the camera, even though it talks about computers and things like that. I think it was sufficient. Cameras are often considered, digital cameras are considered computer hardware, and because they can handle storage like that. So I think it fits within the definition.
Yes, Your Honor.
All right, but based on your request, 429 at 9 o'clock.
Thank you, Your Honor.
And I'll get you that order as soon as I can get off the bench.
Hope you get feeling better.
Thank you, too. God bless you.
Like, Pate pled, right?
Sorry?
Brenda Pate, she already pled?
Yes, Your Honor.
Okay.
Your Honor, this is Haley Pennington, 25 CF 2222, 25 CF 2223. Your Honor, wasn't there a third one?
I don't know. Is this the old charges or the new one?
Old ones.
There was only 2, I think.
Right, and then there's the one new one. Your Honor, she has a probation, I'm sorry, let me retract that. She has a 1129 offer. The state is amenable to inpatient treatment. However, she got rejected from Phoenix House, so now we're trying Path of Grace. So at this point, we're just going to ask for a continuance to the 4/29/26 docket.
All right, Ms. Pennington, April 29th at 9 o'clock. Make sure you follow up on Path of Grace. Make sure that paperwork's going through.
I'll let you know once I know more. Okay?
Thank you. Thank you, Your Honor.
All right, have a good day.
Your Honor, this is Randy Perez before the court on 25 CF 949, 25 CF 2399. If I may have a moment, Your Honor, just to convey a counteroffer by the state.
All right, thank you. Hey, Mr. Barry? I've got a minute. Do you know anything about,
about everything. All right, well, we're not ready just yet because I've got to review the second case first.
Yeah, he pled, and then we talked about him going to like 12 Oaks or something like that, but now they're saying he's never been paid. I'm wondering if he's in 12 Oaks. And so before I give a no bond warrant, can you all take a look at that?
It takes all of us.
My notice says ask Buster. They're trying to violate him because they can't find him. He's probably in 12 Oaks because that's what we talked about for Plea. So, but I don't remember if he was like bed to bars or bars to bed. Maybe the same. You never know. Early mornings and late nights are starting to catch up. What's that? I figure at minimum I'll be on the bench over 30 hours this year. Just
Good to know. Your Honor, we have done depositions of the first case. The second case is brand new. I haven't even reviewed the videos yet. So we are going to request continuance to 4/29/26.
No objection, Judge.
All right, April 29th, 9 o'clock, Mr. Perez.
No,
We'll see
no.
you back on that day.
Couldn't get no closer.
Your Honor, this is Jeffrey Pope before the court on 25 CF 1587. We did have some depositions. The person for the most serious charge, who he was communicating fine, but he felt like he wanted an interpreter, so we had to reset the case. He wants an interpreter who speaks Bengali. So it's going to be interesting.
Language line situation.
Yes, Your Honor, absolutely. So we are requesting continuance to 4/29/26.
Without objection.
Are you able to call language line and like set someone up in advance?
I don't know. I'm going to find out.
Not that I'm aware of, Your Honor.
If I'd like to know the answer to that, because Because every time I've done it, it's like you're just hoping there's someone there,
That speaks Bungali?
whatever language. And maybe even someone who
Possibly.
understands kind of legal terms and stuff. I know that's come up in
And
someone speaking Mandarin once, and they didn't understand the interpreter didn't understand all these terms like downward departure.
all right, so what did you want to do?
May I be excused?
Yes, Miss Leone, have a great night.
I had some pretty bad interpreters.
Don't remind me, I'm gonna have to do this again tomorrow. I think I'm good. I looked at the docket last night, and it didn't look like we had anything too serious that I hadn't read already. Especially bond hearings, VOPs. That's gonna be the problem.
3 of them are going to happen at the same time.
I think we did that before with the one we're talking about today with.
Otherwise, I would have Ivan Rodriguez up here saying the same thing 3 times in a row.
Mr. Porter?
Yep, Christopher Porter.
I'm Rodriguez.
Investigator Ivan Rodriguez.
That's a catcher for the Rangers and the Tigers. And the Marlins. He's a Hall of Famer. Pudge.
There was 2 options, Your Honor, and he had until today to make up his mind which one, and he's now made it, so I got to change it.
And he is.
This is Christopher Porter, Your Honor.
I don't think
And-
I announced on Pope that's 4:29 at 9 o'clock. Sorry, go ahead, Mr. Rivers.
And Your Honor, I did talk to Dr. McDonald today, and you were correct on Mr. Mullis's case, Mr. Mullins' case, about being able to do an evaluation when the person's in another state. She said she'd have to get a special temporary license, and she said it's just not worth it. He's going to have to come from Mississippi. Mm-hmm.
Yeah, that's right. Problem I had that one time, it was juvenile, and the person was in like South Florida that was doing the evaluations. But it was like, as long as he got into Florida jurisdiction.
3.
And then did the Zoom. How do you know that?
Vision.
Drive over the line into Escambia County and then.
The 3 years is ran concurrent, isn't it?
Mm-hmm. 515, court costs on each case, 100, cost of prosecution. Application fee. This was my guess, because we didn't address the missing.
That's fine.
Oh, I'm ready for it.
Sheet.
Oh, goodness.
Mhm. All right, there you go.
Thank you, Mr. Rivers. sure your whiteout sticks.
And Your Honor, that should be court cost times 2. I noticed I only wrote it once.
Are those the guidelines printing?
Yes.
All right, Mr. Porter, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name and date of birth, please?
Lee Porter, October 26, 1994.
All right, and Mr. Porter, you're here in 2025 CF 2221, possession of a controlled substance, third-degree felony, punishment up to 5 years in state prison. Count 2 is resisting without violence, first-degree misdemeanor, punishable by up to a year in jail. And count 3 is trespass, second-degree misdemeanor, punishable by up to 60 days in jail. And then in 25 CF 2304, it's a felony petty theft, third-degree felony, 5 years max. And 2304, count 2 is resisting a merchant, first-degree misdemeanor is punishable up to a year in county jail. Do you understand all that?
I do.
All right. All right, so Mr. Porter, I've been handed a plea and sentencing agreement that calls for you to plea as charged as to, let's see. All right, so it's as charged. It's 3 years probation on the felonies and credit for time served on the misdemeanors?
Yes, Your Honor.
Okay. All right, it's going to be 3 years of probation, Mr. Porter. During that time, substance abuse evaluation and any recommended counseling, no contact with Hibbett Sports, waive cost of supervision, $515 court costs, $100 cost of prosecution. That should be $515 times 2.
Yes, Your Honor.
Actually, $615, right? Because it's a possession.
Well, $515.
$515 on the one and $615 on the other.
$515 plus 100 plus 100.
The drug charge is going to be $615. The other one is $515.
So have the other court costs gone up? Used to be $415.
It's $415 plus 100, but with drug cases, it's plus 100 plus 100.
Right.
All right. So ultimately, $615. I usually just announce it with the cost of prosecution in it.
Okay.
So $615 on 2221 and on 2304, it's be $515. 250 total in PD fees. That's 100, 150. And it'd be an adjudication of guilt, so this would be 2 felony convictions. Do you understand that, Mr. Porter? Okay. And did you have enough time to go over this agreement with your lawyer? Mr. Porter?
Yes.
I'm not sure what Ms. Rivers is writing down that's so important for you to watch.
I mean, we talked about it.
Do you need more time to talk about it?
No.
Okay, that's the question.
Yeah.
Okay. Did you understand the agreement?
I do.
Did you sign it?
Not.
Mr. Porter?
What? Oh, yeah. I signed it.
Every time I look at you to ask you a question, you're staring down at what your lawyer is writing down, which is probably just notes as to what happened with this case.
Yes.
This is the
I
important.
did sign it.
Okay. Are you satisfied with your lawyer's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I've announced? Do you understand that if you enter a plea, there won't be a trial?
Yes.
You understand that you're giving up your trial rights, which are on page 2 of the agreement you signed? And do you understand if you're not a U.S. citizen, this could lead to your deportation? All right, Mr. Porter, what is your plea to the possession of controlled substance, resisting an officer without violence, trespassing, felony petty theft, and resisting a merchant?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty on all counts, both cases. On the felony counts, it's going to be the 3 years probation, substance abuse evaluation, any recommended treatment, no contact with Hibbett Sports, waive cost of supervision. In the 2221 case, it's going to be $615 court costs, $100 PD fee, and a $50 application fee. In the 2304, it's going to be $515 plus 100. On the misdemeanors, it's going to be credit for time served only, no probation. This is a guideline sentence, as you scored 40.80 points. Mr. Porter, I'm going to point out to you